Hello and welcome to our data protection webinar on subject access requests. Uh, I'm Tom Llewellyn, a data protection and commercial litigation partner here at Ashford's, and joining me is Hugh Holston, a solicitor in the same area. As I'm sure you all know, subject access requests, or SARs, have become an increasingly common tool to resolve disputes, primarily in relation to consumer and employment disputes, but also any claim where the respective claimant is an individual. In such circumstances, they're used as an alternative to pre-action disclosure, and although they do provide subtly different outcomes in terms of documents provided, but there is no threshold for making such a request, whereas there is for a standard pre-action disclosure application. That is probably a key reason why SARs are becoming more and more prevalent in disputes. We actually rarely see them being made for the intended purpose under UK GDPR, which is to see what an organisation is doing with a person's data. And SARs can be effective. Take, for example, the information that Nigel Farage obtained regarding his debanking by NatWest. But they can also be potentially damaging. And that's not just in terms of the content, but also any failures when responding to SARs themselves. The recent high-profile example where the Labour Party was reprimanded by the ICO is a case in point. There were 352 SARs that were not responded to, resulting in 150 complaints to the ICO. Hugh will touch on this in more detail shortly, including what can be learned from the errors made here. And subject access requests are a developing area of law with some recent decisions which are focused on and arguably varied how to treat exemptions such as the rights of others exemption. But that's only one area to be considered when dealing with SARs. It's important to ensure that there are robust processes in place from identifying when a SAR is received through to clarifying the scope and then carrying out reasonable searches. And importantly, the obligation here is not to leave no stone unturned, it's just to carry out a reasonable search. I'll now hand over to Hugh. There's a lot to get through in the half hour we've got, so apologies if we do talk quickly or rush through things. But now over to Hugh.
Perfect. Thank you, Tom. So the first thing to consider is really what to do when you receive a request. And I'm not going to go into this in loads of detail because quite often when you do receive a request, it is fairly obvious that you're getting one. The individual might refer to the UK GDPR. They might specifically say that they're making a data subject access request, but the key thing to take away is that there really aren't any formal requirements in terms of the form of how a request might come in. It might be in writing, it might be verbal. Sometimes you'll see it come through various social media channels as well. So it's really just key for anyone within the organization that has a role where they might be coming into contact with these types of requests that they have at least suitable training to be able to identify one, but also the knowledge of who they might need to escalate it to within the organization to be dealt with as well. There we go. Thank you. So in terms of processing the request itself, I suppose at a headline level, it really comes down to making sure that you have an internally documented procedure which is appropriate to the volume and the type of SARs that your organization receives. And part of the reason for doing this is just making sure that the individuals that might work on SARs and the responses have very clearly defined roles. Of course, any individual that might have a role relating to privacy within the business is likely to be involved. More often than not, probably HR will likely need to have some form of role and input as well, in addition to IT, because whilst responding to a SAR not only requires you to have an understanding of the UK GDPR and your obligations in responding, it's also going to require some technical input from either your IT department or potentially even a third-party processor service provider in order to be able to help you with those searches and collate data. So just making sure that everyone knows what they need to do before a SAR comes in is of course critical, so you aren't trying to figure this out when the time frame has started ticking already. As you can see below, I've just included a few suggestions which might be helpful in terms of processing and dealing with a SAR. One is potentially having a dedicated mailbox or email address, which can encourage individuals to submit SARs to a particular email. It is, of course, very important to note that just because you have this doesn't in any way invalidate subject access requests being made by other means, and you still need to be alive to the fact that a SAR really could come in to the organization in many different ways. It's also important to keep an internal log. Now, like many things across the UK GDPR, it's very key to be able to demonstrate your rationale for taking particular steps at a particular time. And indeed, actually having an internal log of all the SARs that you're working on, particularly if you're an organization that receives lots of them, having that sort of matrix of where things are, what decisions have been made, and particularly in line with the timescales that you have, is absolutely critical. In terms of training, I won't go into that in much detail, but again, it's really just thinking about what level of training different people within the business need, or within the organization need, should I say. And that might be relatively low level training for people who might just need a general awareness that subject access requests exist and what they might look like, to much more detailed training to understanding how you actually might apply some of the technical exemptions for legitimately withholding data, which Tom will come on to discuss in a moment. It's also important to have internal coordination. As Tom mentioned, more often than not, we're seeing subject access requests being made in the context of some wider dispute or potential, HR grievance. And so it's very important, if it is distinct teams, one in which is dealing with the response to the SAR and another which is dealing with the grievance, that there is a joined up approach there, and make sure that you are coordinating. It's also very important for the individuals who are actually at that stage of the review where they're considering the exemptions to have a good understanding of that wider context as well, because it might well be relevant to the type of exemptions you apply and to what extent you feel you need to protect third-party personal data. So yeah, just making sure that everyone's joined up is key. As we are relatively pressed for time, I won't go into a great deal of detail about relevant enforcement action around this area, but as Tom touched on, there has been reprimand recently made against the Labour Party. There's also been one made against the Home Office, both of which have been made with regard to failings in both organisations' inability to respond to SARS within the timeframe set out with it under the UK GDPR. Interestingly enough, with the Labour Party situation, they had actually set themselves up a dedicated email address to deal with matters arising from a cyber security incident, to which many individuals had started sending information about subject access requests. The Labour Party then subsequently decided to move away from that and consolidate all communication coming in through their central privacy email address. The trouble was they just then stopped monitoring the cybersecurity email address, and as Tom mentioned, there are around 650, I think, at the final point of SARS that hadn't been dealt with within the timescales required. Similar situation really with the Home Office, albeit on a much larger scale. I think the ICO found that over 20,000 subject access requests had not been dealt within the time frame required. Now, of course, the ICO has a range of different enforcement action that it can take. In these two scenarios, they opted to reprimand these organisations rather than potentially imposing some form of penalty, fine. But it is absolutely key that you are following the process as best you possibly can to avoid enforcement from the ICO, because it can either have a financial impact or certainly potentially a reputational impact as well. So in terms of the scope of the request, of course, that's absolutely key once that's come into you to think about exactly what has been requested. But before doing that, I think it's usually quite sensible just to take a step back and have a little think about what your organization's role actually is. Are you the data controller in this scenario, or are you the processor? Now, this can be quite a technical determination, and I'm not going to go into detail on this call about that. Sometimes it's very obvious which one you are, but of course the data controller is the one that's ultimately responsible for responding to the SAR, whereas a processor has requirements to assist with that process. So just think about where you are in terms of what your personal obligations as an organization might be. In terms of the scope, of course, absolutely key to think about the exact date on which the request was received, because that is the date from which the timeframes under the UK GDPR start to run under Article 12. the rule is that SAR must be responded to without undue delay and in any event within 1 month. However, where there might be multiple requests, or indeed where the request might be categorized as complex, which I'll come on to in a moment, it is possible to extend that by a further 2 months. So all of this needs to be thought about really at the outset. Um, so particularly where you have SARs that are likely to surface up a huge volume amount of data, it's really important to start thinking exactly what is being requested, because depending on the wording of the SAR, it might mean that the request has been qualified in some regard, which may enable you to discount certain information. For example, an individual might have requested data relevant to a particular time period, or they may be seeking data from particular named custodians, or indeed it might be relating to a particular underlying theme. As I mentioned, they may be requesting, for example, all of their data in respect to their ongoing grievance. Um, Rather frustratingly, sometimes, or more often than not, what we find is that people will be quite specific about the information that they want, but at the same time, they'll include some form of catch-all wording, which effectively requires you to search for everything you've got. So have a little think about exactly what's being requested, and then maybe move on to consider whether this is a complex request or not. Now, complexity is really very context specific, and it will depend not just on the nature of the request and the requester, but also the profile of the controller as an organization, i.e., how well suited and what resources does it have and what familiarity does it have with dealing with SARS. All of these things play into the fact of whether or not a case may or may not be complex. As you can see there, I've listed some different examples of things that might be relevant. Volume of data might be one, although in and of itself, just because someone's asked for a lot of data doesn't necessarily mean it's complex. It's more likely to have an impact where, for example, the data being requested is enmeshed with a bunch of other sensitive information, whether that be commercial or whether it involves a lot of third-party personal data, which for various reasons you feel may need to be redacted. Tying into that again is whether or not the organization might need to take specialist advice on those points, and considering which exemptions may or may not be relevant. And also, where is the data held? Have you got it all readily accessible, or are you going to need to engage your third-party processes as well? So taking all of that in the round, you should be able to determine whether or not it's likely that you should be responding within 1 month, or whether it's reasonable and legitimate for you to be extending that period by a further 2. Key thing again there, as I've noted on the slide, just document your reasoning. Um, you know, make sure that you have a record or an internal memo of how it is that you've arrived at that decision, if you are looking to extend that deadline because it's complex. So that really feeds then into the initial response, and I think the key thing really is making sure that you do respond promptly. Particularly so if you are extending the deadline beyond the initial 1 month period, do make sure that you provide an initial response within that first calendar month. Setting out that your acknowledgement of receiving the request, also trying to maybe give them an example or an idea as to when they can expect to receive a response. If you're deeming it to be complex, you should probably include some explanation as to why you've deemed it to be complex as well. That would be really best practice to do that as well. You may find the need that, depending on the nature and wording of the request, that you have some requirement to clarify it. Although the ICO's guidance on that point is that you really do need to make sure that you have a genuine need to clarify the request, and you also need to have a scenario where there is a large volume of data being considered. As part of this, you may be able to seek with the data subject to be able to narrow the scope of the request. Now, it's very important to note that they have absolutely no requirement on them to agree to this. And in our experience, more often than not, a data subject will simply say, no, I want you to give me everything you've got. Although it can be couched in terms of being beneficial for both parties, because whilst not only will it reduce your, the time, expense, resources in dealing with the request, it is quite likely that if you are able to narrow the scope to the information that the individual is actually really interested in, it may enable you to get the response to them sooner. Um, Important to point out that whenever you are seeking clarification, there's the concept of stopping the clock. So whilst you are waiting for that clarification to come through after you've made that request, the time frame for a response is extended by however long it takes them to clarify the request. So again, it can be quite an important tool, but we would certainly advise that you seek to clarify early as possible, and certainly don't be leaving it late on into the first calendar month to be doing that. In terms of the searches themselves, the obligation on data controllers is to undertake a reasonable search. And as you can see there on the slide, the wording from the ICO is not a search which is disproportionate to the importance of providing access to the information, which I appreciate probably isn't the clearest in and of itself, although it does really speak to a couple of cases which we have seen which kind of touch on this point as well. Now, both were heard in respect of the DPA 1998 rather than the UK GDPR as it stands today. However, the principles, underlying principles within these cases are likely to be quite informative for the approach that you should be taking now. In the case of Asiasis and Welsh ministers, the court determined that the organisation had undertaken both a reasonable and proportionate search. And they actually seem to draw a distinction between the obligations on parties to civil proceedings in connection with disclosure and comparing that to a data controller's requirement to search for and provide relevant personal data. And it does appear that the bar is ever so slightly lower, perhaps, in respect of data subject access requests than it would be seen in standard disclosure. Similar can be seen in the case of Itadi and Cheney Gardens, where I think Tom touched on the wording a moment ago. Actually, the court held in that case that the controller's duty is not to leave no stone unturned. And really what they're pointing to here again, and actually what flows through all of these cases and the ICO's guidance, is the principle of proportionality under EU law. Now, of course, I appreciate we have left the European Union, but these are principles which are likely to still be relevant. And hopefully these cases give controllers some comfort that if they do engage in good faith, looking for the data that has been requested, and they make a concerted effort to do so, they are unlikely to find themselves in too much of an issue later down the line if it subsequently comes to light that the odd communication here and there just hasn't been searched for. We would say that if you've made that concerted effort to search, you will have discharged your obligations under the UK GDPR. Just finally on this slide, just a few examples of the types of things you might want to be searching for. And again, this is what requires you to liaise with your IT teams or IT service providers, thinking about the relevant custodians who might hold the personal data, which particular information management systems and servers might need to be searched, whether they're cloud-based or on-premise. Also thinking about particular keywords that you want to be using, of course, names, contact details, initials, and various other signifiers. For example, customer or employee numbers might be relevant things to search for. Again, it's completely context specific and down to that individual case. So just finally, just on the review itself, now, of course, this is by far the most labor intensive and typically expensive part of the process. And depending on the number of documents which are likely to be responsive to the searches, I mean, we see an absolute vast range whereby some SARs that we will work on will only have maybe 50 documents that might be surfaced. Others might have well over 100,000. Depending on where this particular, the SAR that you're working, where it sits on that spectrum, will depend whether or maybe or not you might want to consider using some form of e-discovery platform. There are quite a range of different ones out there, and some of them are very useful and very well adept to working at data subject access requests. I would probably say, even as rule of thumb, even something as low as maybe 200 documents, you might be starting to stray into the territory where it might be cost effective to be using a platform of this nature, because anything that you're spending time doing on potential hosting fees and maybe some professional services in respect of the platform, you're potentially going to save huge amounts in your management time, or potentially fees that you might have to spend paying lawyers to assist you with the process. Um, in terms of the process that we typically go through, we will divide it into two stages. The first of which is more of a high level review, where the aim of the game is very much to seek to cull irrelevant material as far as you possibly can, because for example, when you have 150,000 documents at first surface, it's probably quite likely that in truth, very little of that, or a limited proportion of that, will actually need to be disclosed. So deduplicating information, dethreading email chains, and also removing lots of correspondence which, for example, might only include the individual's email address but has been sent to multiple parties. Things like that can all be worked through and cut down. And I would probably say, as a general rule of thumb, that within that stage one process, you're probably going to be able to get rid of around 75 to 80% of the data that you've initially managed to identify. Stage two, of course, is where the more detailed, I suppose, analysis comes into play in terms of the review, the redactions that you might apply, and of course the exemptions that you might need to apply as well, which Tom is just about to come on to speak about. Final point I'd probably make is that, again, if using some of these e-discovery platforms, you might now be able to actually leverage a number of different automation tools, whether that be to be able to bulk redact certain pieces of information, or in fact even developments now coming along the track with AI as well. I think the one point of caution I would make, and certainly how we act at this stage, is just to ensure that as a final check, everything that goes out under a subject access response has been checked by someone who is suitably trained to deal with that, rather than leaving it to AI or other systems. And on that, I'll hand back over to Tom.
Thank you. So I'm going to talk about exemptions, but I'm actually really going to focus on the rights of third parties exemptions. There's a large number of exemptions that apply. The most common ones we see are legal privilege, information that is relevant to ongoing negotiations between the organisation and the data subject, or this rights of third parties. The first two are relatively straightforward, and rights of third parties is the one that causes probably the most difficulties in terms of considering, but it's also where we've seen the most recent kind of case law developments. So Article 15.4 of UK GDPR states that the right to obtain a copy of your personal data should not adversely affect the rights and freedoms of others. Paragraph 16 of Schedule 2 to the Data Protection Act then states that a SAR does not oblige a controller to disclose information to a data controller to the extent that doing so would involve disclosing information relating to another individual who can be identified from the information, again, with a caveat that unless it is reasonable to disclose information to the data subject without the consent of the other individual. Paragraph 16 of Schedule 2 then continues at Part 3 to list out the kind of relevant circumstances the controller must give regard to when considering whether it is reasonable to disclose that information. And that includes the type of information that would be disclosed, any duty of confidentiality owed, any steps taken by the controller with a view to seeking consent of the other individual, whether the other individual is capable of giving consent, and any express refusal of consent. Overall, it kind of seems clear that the starting point is not to disclose any third-party data unless it's reasonable to do so. However, I'm now going to turn to the impact of some recent decisions, in particular Harrison and Cameron, which might challenge that view. Now, this is a particularly unpleasant case regarding some egregious conduct by Mr. Harrison against Mr. Cameron. In short, Mr. Harrison contracted with Mr. Cameron to carry out some landscaping work through Mr. Cameron's business, ACL. They fell out and the contract was terminated prior to completion of the work. There was then a dispute about payment for works completed up to the point of termination. This resulted in a number of threatening phone calls from Mr. Harrison that Mr. Cameron covertly recorded and then shared with colleagues, family and friends. Mr. Harrison found out that his recordings had been circulated and alleged that they had reached key individuals within the property industry, resulting in losses to his business. He wanted to know who had sent the recordings to whom, and so made a SAR. The approach of Mr. Harrison and his lawyers was particularly aggressive, and that's a key factor in the ultimate decision in this case. So whilst we are focusing on the rights of third parties exemption, the starting point is actually whether the details of recipients or categories of recipients should be provided. In Harrison, the SAR contained a request for details of individuals' details. In particular, so Mr. Harrison could identify them and include them in a proposed course of litigation. The request for details is subject to Article 15(1)(c) of UK GDPR, which requires the disclosure of recipients or categories of recipients to whom the personal data have been or will be disclosed. Coming to a decision in the Harrison case, the judge considered the CJU Austrian Post case, which held that a requester is entitled to be informed of the actual identities of individual recipients of their personal data, not merely the categories of recipients. That shouldn't be controversial. The judge then held that recipients includes the employees of the data controller. This has previously not been positioned in an earlier CJU case, JM Pankies. The court held that the identity of controllers' employees did not need to be disclosed. It was subtly different than it was people who had accessed data rather than received it in that case. But the point being, the identity of employees was not considered to be recipients because they were internal. The Harrison decision is therefore a clear widening of the scope of Article 15(1)(c) and therefore a narrowing of the right of third parties exemption. The only exemptions to this are: one, if it's impossible to provide this information, if the request is manifestly unfounded or excessive, or a valid exemption to disclose that exists under UK GDPR. But otherwise, per Harrison, you should now provide the details of internal recipients of data as well as external recipients of data. So what's the ICO's position? Well, the ICO offers advice to data controllers responding to SARs, which involve personal data of third parties. In such cases, the ICO encourages data controllers to first consider if they can comply with the SAR without disclosing third-party information. Now, this does, on the face of it, seem inconsistent with the Harrison decision, which states that, as we've just heard, there is an obligation to provide details as to the identity of recipients. The ICO then goes on to state that if that compliance is not possible, then the controller does not have to comply with the SAR unless the third party consents to disclosure, or it is reasonable to comply with the SAR without the consent of the third party in question. And an important point to note here is that employee consent is generally not taken to be freely given and therefore insufficient in terms of has consent been provided. So turning back to the Harrison case, Mr. Cameron and ACL refused to disclose the identities of the recipient of the recordings on a number of grounds, including reliance on the rights of third-party exemption. They argued that the recipients of the recordings had not consented and that it was not reasonable to disclose information to Mr. Harrison without this consent because of his wider intent to involve them in prospective litigation. The court held that in determining whether disclosure was reasonable or not, Mr. Cameron was obliged to carry out the balancing test in paragraph 16.3 of Schedule 2 of UK GDPR and have regard to all of the circumstances set out in that provision. Note also at this point that the ICO advises that if the third-party information relates to a member of staff who the data subject knows well from previous dealings, then the information relating to them is more likely to be disclosable than that relating to an otherwise anonymous individual. It is not a determinative factor, but it's something that must be considered. So in Harrison, the court ultimately held that Mr. Cameron and ACL have discharged their obligations under Article 15 when responding to the SAR, and that Mr. Cameron was entitled to rely on the rights of others exemption when refusing to disclose the identities of the recipients. The court held here, in particular, that data controllers are the primary decision makers in assessing whether or not it is reasonable to disclose third-party data, and importantly, that data controllers have a wide margin of discretion to decide what is reasonable within the context of the request. In this instance, the court held that it was reasonable for Mr. Cameron to take into account that disclosing the identities of the individuals would put them at significant risk of being the object of intimidating, harassing, and hostile legal correspondence and litigation from Mr. Harrison. And this is a really important development that reinforces that data controllers have ultimate responsibility for the personal data they hold. Whilst the first two elements of the decision do seemingly narrow the scope of the third-party rights exemption slightly, this final element of the Harrison decision has countered the effect. The reality is that as the data controller, you are responsible for the data you hold, and any unauthorized or unjustified disclosure could result in a claim from a third party for a breach of their rights. The courts have seemingly recognised that and afforded and recognised this wide margin of discretion. So this case really has provided some very useful clarification on how to apply the rights of third parties exemption, but I think it would be a stretch to say it's clarified everything. Harrison was an extreme case because of Mr. Harrison's conduct and approach, and the court referenced the intimidating, harassing, and hostile legal correspondence and litigation. But what if it's just regular litigation? There's clearly scope and need for further clarification, but in the meantime, where this issue arises and it's likely to be contentious, data controllers need to carefully consider the application of the exemption and how to apply the balancing test. I would say the starting point now has to be that third-party recipient data should probably be provided where requested, unless there's a good reason not to. But where there is a good reason, and that can include potential involvement in wider litigation, a data controller has a really wide margin of discretion here in terms of how data under their control is disclosed. Kind of final additional point is that the court held in Harrison that the context in which a SARA is submitted may be a consideration in determining whether it is reasonable to apply the rights of others exemption. And I'm conscious, just looking at the time, that I've slightly gone over the half-hour limit. So I hope we'll only be 2 more slides, and I hope you can bear with us for a few more minutes. The judge in Harrison cited a case and transcription agency, which noted that the SAR regime has a specific and limited purpose, which is to enable a person to check whether a data controller's processing of their personal data unlawfully infringes their rights. So the court considered that it was reasonable for the defendants to give weight to that and to a desire to protect family, friends, and colleagues from litigation in circumstances where the SAR really did seek to, enforce rights which were beyond the extent of UK GDPR. So again, a further point to consider if that is the context in which SAR is made. So finally, you've completed the review. You've applied the exemptions. What next? Well, you need to send a compliant response letter per Article 15 of UK GDPR. So as well as providing the data, you will set out the purpose of processing, the categories of data, and recipients of data, and confirm people's right and the confirmation of rights, including the right to complain. You should share in the format requested. So if it's received if the request is received in an electronic format, you should share electronically. You should obviously share securely, provide encrypted email or a portal. We would recommend a portal, not least because if there's any security concerns, access to the portal can be closed off. As a last resort, send it via post. Again, if you do so, put it on an encrypted device and send the password separately. So that now brings an end to our talk. Apologies that we've gone slightly over the time limit, but thank you very much for listening. Whilst we haven't got time for a Q&A, if you do have any questions, please do not hesitate to reach out to myself or Hugh directly. We'd love to answer any questions you might have. Thank you very much.
Thank you, everyone.